In this immigration law update video, I want to consider some of the recent developments from the Court of Appeal in cases involving Article 8 and deportation. And we know that deportation cases are very difficult, and this is a very difficult area of law. In these immigration law update videos, what I'm trying to do is give a quick summary of recent case law, statutory and policy developments. If you want more detailed and in-depth training, sign up to one of my seminars through organisations such as HJT Training Limited, MBL Seminars and the Solicitors Groups. And I've got upcoming events around the country. So the law in relation to deportation in Article 8 is primarily now found in the amended section 117C of the 2002 Act. And it says that the deportation of foreign criminals is in the public interest. The more serious the offence committed by a foreign criminal, the greater the public interest in deportation of the foreign criminal. And then it applies two exceptions to those who've been sentenced to under 4 years imprisonment. The first exception, exception 1, concerns private life, and that looks at whether somebody's been lawfully resident in the United Kingdom for most of their life, whether they're socially and culturally integrated into the United Kingdom, and whether there would be very significant obstacles to integration into the country to which they're to be deported. The second exception applies to where there are relationships with a qualifying partner or a qualifying child. So this is the family life exception. And this says that, or the test applies to, is whether deportation would be unduly harsh on the partner or the children. And then finally, in a case where somebody's been sentenced to 4 years or more, there have to be very compelling circumstances over and above those exceptions. Though that applies also to somebody who's been sentenced under 4 years but can't meet the exceptions. Now, that is mirrored in the immigration rules at paragraph 398 and following of the immigration rules. Just as an aside, I've recently come across some cases where somebody's been deported and they want to come back to rejoin their family in the United Kingdom. So there's been an application under Appendix FM as a partner. But what hasn't been done is that it hasn't been an application before that for revocation of the deportation order. So the Appendix FM application has failed and been refused under suitability grounds because there is an extant deportation order. Have a look at paragraphs 390 and following of the immigration rules as to the application for revocation that needs to be made in advance of any entry clearance application. But let's get to these Court of Appeal cases. And the first thing I want to look at is the exception 2, an unduly harsh. In 2018, we had the Supreme Court case of KO, Nigeria. And in KO, the Supreme Court held there that in the assessment of unduly harsh, this is not a balancing exercise comparing the rights of the partner or the child against the public interest, but it is a consideration which focuses only on the partner or the child and looks at whether the effect upon them would be unduly harsh. That is, there is a degree of harshness which is beyond that would be expected to normally be faced in a deportation context. Now, what's happened is the Court of Appeal have been overturning a number of cases where the tribunal have held that the circumstances would be unduly harsh. The leading case is the Secretary of State and the Home Department and PG Jamaica, which is from 2019, EWCA Civ 1213. And at paragraph 39, Lord Justice Holroyd talks about the distress that would be suffered by the appellant's 3 children and his partner if he was deported and how their lives would be made more difficult. But he said, look, these are just the likely consequences of deportation and don't make it unduly harsh. He says this: many parents of teenage children are confronted with difficulties and upsetting events of one sort or another and have to face one or more of the children going through a difficult period for one reason or another. And the fact that a parent is a foreign criminal who will no longer be in a position to assist in such circumstances cannot of itself mean that the effects of his deportation are unduly harsh for his partner and or children. So the Secretary of State was successful in their appeal in that case. The Court of Appeal came to a similar view in the case of KF Nigeria 2019 EWCA Civ 2051. What about the test of very compelling circumstances over and above? Well, this is a difficult test and the bar is set very high indeed. That high bar, very high indeed, comes from paragraph 63 of the case of OH Algeria versus the Secretary of State for the Home Department, 2019 EWCA Civ 1763 from the 24th of October 2019. Have a look at paragraph 63, where the Court of Appeal emphasised this and the fact that if a judge is going to find there are very compelling circumstances, full and clear reasoning will be necessary. When considering very compelling circumstances, is the public interest fixed or variable, movable? Well, in a helpful case called Akinyemi in the Secretary of State for the Home Department, 2019 EWCA Civ 2098 from the 4th of December 2019, the Court of Appeal found that the public interest was variable. In this case, Akinyemi was born in the United Kingdom in 1983, had lived here lawfully all of his life. He'd never acquired British citizenship, and despite being here for those many years, he had a significant criminal history and suffered from mental health problems from a young age. He'd been sentenced to over 4 years imprisonment. And the Court of Appeal found that the upper tribunal had erred in their approach to the public interest and remitted the case back for the second time. And Sir Ernest Ryder said this at paragraph 39, the correct approach to be taken to the public interest in the balance to be undertaken by a tribunal is to recognise that the public interest in the deportation of foreign criminals has a movable rather than a fixed quality. It is necessary to approach the public interest flexibly, recognising there'll be cases where the person's circumstances in the individual case will reduce the legitimate and strong public interest in removal. The number of these cases will necessarily be very few, i.e. they will be exceptional having regard to the legislation and the rules. I agree with the appellant that the present appeal is such a case. And he relies heavily on the judgment from 2016 of the Supreme Court in Hesham Ali and says how Part 5A of the 2002 Act, of which Section 117C is part of, does not fundamentally alter the principles to be applied to the assessment of the public interest. Have a look at that. What about persistent offending and integration? In Binbuga, Turkey, and the Secretary of State for the Home Department, 2019 EWCA Civ 551, that's back from the 4th of April in 2019, the Court of Appeal considered these questions of persistent offending and integration. This was the case that hit the headlines, where a first-tier judge had found that a mark of the appellant's integration was his membership of a North London criminal gang. That had been overturned, unsurprisingly, by the upper tribunal. The Court of Appeal held that somebody who's a persistent offender is somebody who keeps on breaking the law. Even though he may not have offended for some period of time, you have to have a look at the individual circumstances. They went on to look at the question of social and cultural integration and found that you should look for things like membership of clubs, workplaces, acceptance of core values, ideas, customs and social behaviour, including an acceptance of the rule of law. So membership of a criminal gang was not evidence of social and cultural integration. Interestingly, the Court of Appeal had looked at this phrase, homegrown criminal, something a number of us have used and argued. It goes back to a case called HK Turkey, and we've argued this in cases to reduce the public interest, but they found that this phrase was unhelpful and didn't withstand analysis. Finally, in relation to social and cultural integration, the final case is CI Nigeria in the Secretary of State for the Home Department, 2019 EWCA Civ 2027 from the 22nd of November 2019. This looked at whether prison broke social and cultural integration. Lord Justice Leggett said at paragraph 77, the judge should simply have asked whether, having regard to his upbringing, education, employment history, history of criminal offending and imprisonment, relationship with family and friends, lifestyle and other relevant factors, CI was at the time of the hearing socially and culturally integrated into the United Kingdom. The judge should not, as he appears to have done, have treated CI's offending and imprisonment as having severed his social and cultural ties with the UK through its very nature, irrespective of its actual effects on CI's relationships and affiliations, and then required him to demonstrate that integrated links had since been reformed. The Court of Appeal also found that the upper tribunal had erred in its assessment of very compelling circumstances by failing to apply the Maslow principles, looking at where a settled migrant had been here for most of their life. It's a helpful summary, this case, of the enduring principles from Maslow. That's Maslow and Austria, 2009, INLR 47. And have a look at paragraphs 103 to 114 of CI Nigeria. So that's a summary of some of the recent case law coming from the Court of Appeal in this difficult area of Article 8 and deportation. And those cases are well worth a look when you're arguing your cases. I hope that's helpful.